So you were to tell your attorney whether, of Bright versus Starr, you were to tell your attorney the authority for whether the Superior Court in Riverside County had subject matter jurisdiction, in persona jurisdiction, and what the venue would be, what court in Riverside County. How many issues is that?
3, 4.
3 issues. Subject matter, separate law, in personam, you need law for that, and venue, you need law for that. So, I don't think anybody, well, I'm pretty sure, nobody, I think actually one person took a stab at the law for subject matter jurisdiction. You all just assumed that the court had subject matter jurisdiction. Your assumption was correct because it's such a simple question, and as I said in my announcement that your attorney wouldn't be assigning that particular thing to you, but the assignment did. And so you had to address it, and you had to find the law. What law gives the Superior Court jurisdiction over that cause of action? And nobody gave me that law. Nobody even treated it as though it was different than personal jurisdiction. So the first thing is, do you understand that it's different? That personal jurisdiction is separate, completely separate and distinct from subject matter jurisdiction. You cannot lump them together and say that because they have personal jurisdiction, they also have subject matter jurisdiction. They are not interchangeable at all. So the question is, where does the Superior Court get its subject matter jurisdiction over this type of cause of action? Now, the disadvantage that you have in that, admittedly, is that we don't have a good method for you to do legal research. You know, you can't. I tried to get it. I did get it. I tried to get it just by Googling, and I did find it. But I'm not too sure that you would have recognized it. You know, I mean, it was there. It's in the California Constitution. It wasn't in my PowerPoints. It's in the California Constitution. It's a section in Article 6 of the California Constitution that gives the Superior Court original jurisdiction in basically all matters except some that are enumerated. And so this would not come within an exception, and so it would be Article 6 of the Constitution. And that's all you would have had to put for that first issue. But then getting to the second issue, this is lumping all 3 in, and this was the total statement of the analysis. Is that analysis? Do any of you think that this is analysis? Why not?
It's not applying them to your problem.
What is it analyzing? It's just making a statement that this is supposedly the law. Now, you're supposed to be informing your attorney of something. And pretend I'm your attorney. What does that tell me? It tells me go fish. Go look at it. It doesn't even give me what it says. So I have no way of knowing without looking up to see whether these are the right code sections at all. Here's another one that's the sum total of the analysis. Is that analysis? Hold on, sorry. There.
That looks like it was cut and pasted.
I don't mind if you cut and paste the law, but why in the hell
You
do
don't?
I have to know about real property? This is not relevant to the facts at issue. Why do I have to know anything about right now for this memo? Why is there anything in here about the recovery of real property? Or the foreclosures of liens?
I crossed practice exam 2 with the assignment 1.
this is unlawful detainer. This has to do with the tenant getting it kicked out.
So we would just copy and paste the sections of that were relevant, and then we would put like dot in between the stuff that you don't need to know about, and then
Yeah, but actually, there's nothing in here that's relevant in this one. But if there were something, you could, yeah, you could cut, it's okay to cut and paste it.
But it's okay to
Because you're stating the law.
dissect it a little bit and
But it's
make it
not
clear.
under a statement of the law, it's under analysis. It's not analyzing anything. Just telling me what the statute says is not analysis. So I don't want to just say it to you, I want you to kind of understand, I want you to understand it.
So do you want us to interpret the code?
I want you to apply it to the facts. And unfortunately, the reason this can't be applied to the facts is because it's totally irrelevant to the facts.
So then is that the wrong code?
Yeah,
Okay.
it's the wrong code, right? So you ought to know that when you put something in there and you can't argue it to the fact, you can't apply it to the facts, so you must have something wrong, you know? Okay? So I guess, I don't know how, you know, it just comes so naturally to me, I have to figure out how to explain to you all as to what kind of analysis is required. Because to me, I'm looking at this and I'm thinking, how could anybody think that's analysis? Can you see the problem with that? Sure. You're really not supporting the conclusion that the court has subject matter jurisdiction, or that the court has in persona jurisdiction, or where the venue is. You're not supporting it just by citing the law. If you don't apply it, you're not supporting it. And that's the purpose of the memo, is to convince the attorney that you found the answers, and the attorney doesn't have to. That's one of the things.
So,
Yeah, go ahead. No, I welcome all three.
are we doing the attorney's job?
Oh, my God! What are you there for?
Okay.
All right, have you had
No further
law
questions.
office management?
No. No further questions, though.
It's a team, it's a legal team. And to the extent that a lesser billing hour rate can be billed to the client, that's who performs that work,
So be it.
okay? That's why the attorney says, here, write a memo on this. Because
Save-
you
save
spending
the
time
client some
on it is
money.
gonna save the client's money, yeah.
Gotcha.
Are you doing the attorney's work? One would
Yes.
hope so,
Okay.
because otherwise, we don't need you there. Okay?
Right on. No further
Just,
questions.
you know, if it don't whip you, it's good enough, you know.
So when you find the proper one that you think is it, do you cite it and then the section, and then you have to like summarize it?
You could summarize it if it's really simple, you know.
But don't
You
just
don't always
cite
have to
it.
set it up. But don't just cite it, you have to apply it.
So you
Don't
have to
just cite it.
explain why
You have
it is.
to tell the attorney enough about what it is and why it applies.
Do you want us to find a case that used that and cite the case?
I was vague about that in the assignment because this assignment really didn't need case citation. If you found one, a couple people last time I gave the course did find one that applied. And if you found one and you cited it, that would be fine. But you sure better put something in there that doesn't make me look it up.
This might be a stupid question, but could there be more than
No,
one
it's stupid.
code that could work for whatever
There
situation?
might be
'cause-
more than one code that applies.
Right, right.
Yes. You guys found all kinds of codes that didn't apply at all.
It's
And
like
that was what was
needle in a
surprising
haystack.
to me.
We need
Well,
some guidance.
I think it would be easier for you if you had, here, let me show you something. By the way, I'm going to do a mini grant. I talked to the dean tonight. I had a meeting with the dean tonight. And she asked me to do a mini grant to get us a grant for online legal research.
Next is Lexus.
I hope not. But probably because we already have Lexus. So I've never done it on Lexus. I've used Westlaw.
Okay.
you go online and you can just look into a legal treatise, or you can look into, there's, you know, the really heavy-duty online legal research is not like looking through a needle in a haystack.
But we don't have access to that.
But you don't have access to it. But you did have access to my PowerPoints, and except for Article 6 of the Constitution, all the other statutes were there. So in that summary, I told you that I listed all those statutes you all cited. What, did you read them? I couldn't figure out why you were citing them. They were eminent domain statutes? What did that have to do with it?
We are seizing the land that car had an accident.
And a lot of people really liked 410.50. What did that have to do with anything?
It looked like it fit.
410.42, I didn't want to put it in, I don't know where it is. It's the one for work for improvement. If you're a contract for work for improvement, I said that starting to it's section 410.42. I said the start into the contract for work for improvement on his vehicle for the California company when he signed the receipt for the police. So that, did it work? I didn't put it in there, I just wrote it down.
All right, let's go to 410.50, which some of you cited as 410.5, by the way. Typos don't help either. What is the website? Info.ca.gov. Okay. Can you all see that?
Yes.
Except as otherwise provided by statute, the court in which an action is pending has jurisdiction over a party from the time summons is served on him. Well, but that begs the question.
How did you serve him?
Under these facts, he hasn't yet been served even. So, just because, this is only saying, if the court gets personal jurisdiction over him, it has that jurisdiction for the rest of the lawsuit. This is not saying that this is a way to get personal jurisdiction over him. This is not conferring. This would confer personal jurisdiction on anyone who gets served, and you know that can't be the case, right? You see that? What you would have to do there is go to the annotations. You know what the annotations are? How many, raise your hands if you've had legal research already. I want to see it. Okay, so, I mean, it bothers me that you've had legal research and you didn't know how to do this one. Has jurisdiction from the time the summons is served is provided in Chapter 4. But that just says, that doesn't mean that the guy can't come in and say, I'm going to quash service of that summons because you can't get personal jurisdiction over me. This does not confer personal jurisdiction. Because can you see that if it conferred personal jurisdiction, they could never, ever contest it on any basis. All you would have to do is serve a summons. And that's not the law. The law is that constitutionally you have to have minimum, the defendant has to have minimum contacts with the state. So the due process requirements are satisfied. That's the law about personal jurisdiction. This statute, under your interpretation, would confer it every single time and you could never ever contest it. It could confer it, some guy could live in Alabama, California resident is driving in Alabama, has an accident, sues the Alabama guy in a California court, serves him with a summons. So if your interpretation held for this statute, that would mean that Alabama guy would be subject to California court's jurisdiction. Do you think he would be under the facts I just gave you? No. Right. So that's why that is absolutely no good. So this didn't apply at all. Do you understand what this one does mean? Once there's good service and jurisdiction attaches under the constitutional requirements, then the court has it throughout the subsequent proceedings. court doesn't lose it, that's all it's saying. When you have your statement of relevant facts, you know, you only needed about 3 sentences. Because all you need in a memo are the facts that are relevant to those issues. So it was not relevant that Bright claimed $50,000 in medical bills, for example, because that has nothing to do with whether personal jurisdiction attaches. That is relevant to subject matter in terms of unlimited versus limited. Correct. So one sentence of Bright claimed more than $25,000 in damages would take it out of the realm of the limited. It is relevant to that. And I thought, too, that it was okay to say that Starr had his brakes repaired at a shop in Temecula, because that's another little tiny contact thing. Turns out it didn't really matter, but it would have been fine to say it.
I thought Tim's auto repair was in Riverside.
It's in Temecula.
It is?
Yeah.
I looked it up and I was like, no, maybe there's more than one.
You looked up what?
Tim's auto repair?
Oh, well, that's just in the high school. That was just a
I know,
name
you
I
thought
threw out
that
of
was
my...
just see where it's
Well,
at?
no.
No.
Where it's at is where the hypo says it's at.
Oh, okay.
Anyway, so I just want you to know, I didn't really grade down too much. Well, you all know that I'm hoping that you redo these, and that will become your real grade. I'll pass these back so that you can see my comments on them. And just as a matter of form for doing memos, you always shade your relevant facts to just those that are relevant to that issue. You don't put things in there about Starr agreed to mediate. That's not relevant to the issue that was presented by the scope. Okay, so there are also some issues with respect to the way you're citing things, and your citation method is incorrect. And I'm not, even if you've had, how many of you have a copy of the California Style Manual? How many of you have ever heard of the California Style Manual?
Is that the blue book?
Or the blue book, that's
Well,
a
I
different
got
one.
that blue book, but
You
God
got the
knows
blue
I've
book.
never cracked it.
Okay, so
I-
you're going to be held to the standard of someone who owns a blue book. You can't just willy-nilly cite it. You do not get to just do it. I told you, I just willy-nilly do it because I'm trying to shortcut the time that it's taking me to type all these things into the PowerPoint. So, but CCP is not a correct way to cite it. There are a lot of people, the Rudder Guide, there are treatises and everything that do cite it that way. I don't know why it's not the correct way to cite it, because we all know what it means. It would be a much easier way to cite it, but it's not.